Good morning, everybody, and welcome to this, the third and final webinar in our Charities and Third Sector Spring webinar series. My name is Kenneth Pinkerton, and I am the Director of Charities and Third Sector here at Brodies. I'm absolutely delighted this morning to welcome Christine O'Neill and Finlay Mackenzie, who are both solicitors in our Government Regulation and Competition team, to discuss with you equalities law and the interaction with charity law. Christine is chairman here at Brodies and a recognised expert on public and constitutional law issues in Scotland. She's an accredited mediator and a solicitor advocate and was appointed as Queen's Counsel in 2020. She's a member of Brodies' Charities and Third Sector team, advising the Scottish Charity Regulator and a number of charities, and has appeared in the First Tier Tribunal, Upper Tribunal and Court of Session in charity cases. Christine advises clients on legislation and statutory interpretation, the powers and duties of public bodies, including the Scottish Parliament, freedom of information laws and data protection, amongst many other things. Finlay advises clients on a wide range of regulatory and public law matters, including compliance with equalities law. He also has experience in advising charities and regularly advises Oscar. So equalities law is obviously something that we are all, as charity lawyers and those in the charity sector, very interested in, and something that's very much tied to our activities. And with us coming out of the pandemic and arguably looking at other activities, it's certainly something that we should have an eye on. So without much further ado, I will hand over to you, Christine, to take us away.
Morning, everyone, and just to give you an overview of what we're going to cover this morning, I'm conscious that we could talk about equalities law for days and days, but you don't have days and days, and we wouldn't keep you for that length of time. So we are going to treat this at a reasonably high level, just by an introduction to what is equalities law. We'll touch on why compliance with equalities law is important. We'll also look at how equalities law applies particularly to charities, and give you an overview of the Equality Act 2010 and some of the key provisions that are likely to be important to you as charities. And as Kenneth has said, we will take questions at the end as well. So if we move on to the first introductory point, which is what is equalities law, this will be familiar to many of you, but equalities law in Scotland comes from a number of different sources, including Acts of Parliament and court decisions. Now, the main source of equalities law now in the United Kingdom, and the one that we'll be looking at most of all in this session, is the Equality Act 2010. And the Equality Act is an act of the UK Parliament and applies broadly across Great Britain, with Northern Ireland having some separate provision. But the 2010 Act has two main purposes. The first is to harmonise discrimination law, because prior to the 2010 Act, we had discrimination law in a range of different statutory provisions, and to strengthen the law to support progress on equality. So the 2010 Act wasn't just about bringing equality provisions together, it was about progressing and making those stronger. And what the 2010 Act does is it makes certain behaviour unlawful. So it prohibits certain conduct in certain quite specific circumstances, and it imposes duties and obligations on those who are regulated by the Act. Now, in addition to the 2010 Act itself, there are also regulations made under the 2010 Act that apply to the different parts of the UK or Great Britain more properly. So there are separate what are called specific duties regulations. So when you are working in Scotland and thinking about equality law in Scotland, you need to think about the Equality Act itself, but you also need to think about the Scotland specific duties which were made in 2012. So if we move on, I think probably the key thing that we want to convey about why compliance with the Equality Act is important for charities is that in many respects being a charity doesn't matter. So many of the duties that are imposed by the 2010 Act and many of the prohibitions which are made by the 2010 Act will apply to charities in quite the same way that they would apply to other organisations. So at one level, it doesn't really matter that you are a charity. We'll come back to the charity specific provisions, but in many respects, it simply matters that you're an organisation that employs people or delivers services, and we'll come on to the various ways in which it might hit your organisation in a moment. Again, I think the thing to remember is that a failure to comply with the 2010 Act can have a range of consequences. It can result in claims, so there could be formal litigation against your charity. I think probably as important, if not more important to many of you who are watching today, would be reputational damage. I think it's very clear that an allegation of a failure to comply with equalities legislation, a failure to treat people properly, or an allegation, more specific allegation of, for example, discrimination or harassment or victimisation, can have very serious reputational consequences. There might also be regulatory action in terms of enforcement action by the Equality and Human Rights Commission, and there might also be regulatory action by OSCR if it is concerned about your compliance with your obligations under the Equality Act. So if we move on to that specific question of how it applies to charities, I've mentioned already that being a charity actually doesn't matter terribly much, except in relation to the charities exception, which we will come along to. But if you think about the range of ways in which the Act might affect your organisation, it will be relevant to the decisions that you take and the action that you take that affect your employees, members and volunteers. So in each of those situations, the Equality Act may be relevant. It will be relevant to the policies and procedures that you adopt within your charity, both internal and external. It will be relevant to how you fulfill your charitable purposes, so the action that you take in furtherance of your charitable purposes. It will affect how you make decisions and what kinds of decisions you can make about who can be part of your charity or benefit from your charity's work. And it will also be relevant to the way in which you deliver services, including where those services are commissioned by other agencies. So if we move on, I've mentioned the potential for legal action to be brought for a failure to comply with the Equality Act. That kind of legal action might be brought against the charity itself, or it might be brought against individuals who represent a charity. And one of the issues to be aware of is, and I'm sure many of you are aware of this, the charity as an entity, as an organisation, can have legal responsibility, and that's known as being vicariously liable, but you can have legal responsibility for the actions of your employees, even if their behaviour was done without your knowledge or approval. So in an equality context, if there has been a breach of the Equality Act by one of your employees, that can lead to a claim against the charity, even if you didn't know what the employee was doing. And it's important to understand that a defence to a claim under the Equality Act includes a defence that the employer took all reasonable steps to prevent the unlawful conduct of the employee. So one of the ways in which a charity may protect itself against claims arising from what's done by employees is by taking steps to make sure that your employees don't breach the Equality Act. Difficult to guarantee that, but obviously you can do things like ensure that you have appropriate policies and procedures in place, that you deliver appropriate training, that you put in place appropriate supervision mechanisms and ways of dealing with complaints. So there are ways in which you can obtain some protection under the law. One of the questions that we've been thinking about in advance of this session is whether you might be liable for things that volunteers do when they are working with you. And there's a quite separate question about how you might be liable to volunteers of your own if you treat them badly in terms of discrimination. But what about the situation where you have volunteers who are delivering services for your charity? There was a case, and it was under the previous discrimination legislation, but it would apply equally in relation to the 2010 Act. There was a case in the Supreme Court that asked whether a volunteer could obtain effectively employment law type protections under the Equality Act, where they were where they were discriminated against or alleged that they were discriminated against by the charity for whom they volunteered. The Supreme Court said no, they don't get to sue the charity for discrimination law purposes. But that's a separate question to whether you as the charity might be liable if a volunteer does something to a service user, for example, where they are doing that on your behalf. And there are decisions of the courts that suggest an employer can be, or an entity can be liable for the actions of unpaid volunteers. So again, it's just about an alertness to the need to make volunteers and anyone else who's delivering services on your behalf aware of your obligations and theirs under the Equality Act 2010. So if we move on, I think at this stage, I am going to hand over to Finlay, who's going to talk a little bit more about what the 2010 Act actually requires of you and others. Finlay.
Thank you. Yeah, as Christine's already highlighted, the main source of equalities law in the UK is the Equality Act 2010. And in very basic terms, the 2010 Act makes it unlawful for organisations to do certain things. And these include discriminating, victimisation and harassment. And this is what we refer to under the Act as prohibited conduct. And often allegations against an organisation will be on the basis that an organisation is engaged in this prohibited conduct. So I'm going to give a brief overview of what some of the prohibited conduct under the 2010 Act is. So prohibited conduct under the 2010 Act focuses largely around the concept of protected characteristics. And you'll see on the slide what the protected characteristics under the Act are. And these include things such as a person's age, disability, race, for example. And the idea being that these are characteristics that often form the basis or the reason for discriminatory behaviour. So what will be important is when considering potential prohibited conduct to first identify the relevant protected characteristic or protected characteristics. So the first type of discrimination or the first type of prohibited conduct I wanted to discuss was direct discrimination. And direct discrimination occurs when A treats B less favourably than A treats or would treat others because of a protected characteristic. So just breaking that down, there's a requirement for less favourable treatment of a person. And the less favourable treatment must be because of a protected characteristic. So for example, the person's religion. A good example of direct discrimination is a Supreme Court case, Hall against Bull. And it was held that two hoteliers, Mr. and Mrs. Bull, who had a policy to only let double-bedded rooms to married couples, directly discriminated against two homosexual men in a civil partnership on the grounds of sexual orientation when they refused to let them a double-bedded room. So the less favourable treatment was the refusal to let the double-bedded room. And this treatment was as a direct result of a protected characteristic, in this case, sexual orientation. And in this example, the less favourable treatment was relatively obvious, quite easy to identify. But identifying less favourable treatment may not always be straightforward. And what is necessary is to identify a comparator. So what this means is identifying someone or a group of people who are in similar circumstances, but who do not have the protected characteristic. So just by way of example, there was a case where a waitress was dismissed on the grounds that women with children were unreliable, and the court held that the treatment of the waitress ought to be compared with a man with children. So the comparator to a woman with children being unreliable was a man with children in that case. So just moving on to indirect discrimination. This occurs where a provision, criterion, or practice is applied which puts or would put people who share a protected characteristic at a particular disadvantage. So this requires a provision, criterion, or practice, and that the application of that provision, criterion, or practice puts persons with a protected characteristic at a particular disadvantage. As the name suggests, the discrimination in this case in this prohibited conduct is less direct, because a policy could be created with seemingly good intentions, but nonetheless falls foul of this provision. And the purpose of this part of the Act is really to force organisations, when creating policies, for example, to think about the disadvantage that may arise as a result of that policy for persons with protected characteristics. And for that reason, it will not be a defence for an organisation to say that it was simply unaware that the policy, criterion, or practice placed a person with a protected characteristic at a disadvantage. However, what is important to note is, unlike direct discrimination, it is possible to justify indirect discrimination. And this will be on the basis that the actions taken were a proportionate means of achieving a legitimate aim. Now, you'll hear that phrase repeatedly throughout this webinar, and that's because it comes up repeatedly throughout the Act. And what it exactly means has been the subject of some discussion in the courts. We'll touch on that very briefly later on. But what is important is that the justification cannot be used to justify indirect discrimination after the fact. So an organisation will need to show that at the time of creating a policy, for example, that it considered this disadvantage and was satisfied that its actions were a proportionate means of achieving a legitimate aim. And this just comes back to the notion of forcing organisations to think about discrimination and prevent discrimination before it actually can happen. So the next type of discrimination is disability discrimination. And you'll see in the slide that the Act specifies what amounts to a disability for the purposes of the 2010 Act. And I won't go into each point, but you'll see what it does is provides a broad definition of what can amount to a disability, and it will capture most disabilities. Nonetheless, one of the first questions you may ask when considering disability discrimination is whether the person complaining has a disability, which is a disability for the purposes of the 2010 Act, and most disabilities will be included. So the test for disability discrimination is similar to the test for direct discrimination, but with some important differences. The test for disability discrimination is if A treats B unfavourably because of something arising in consequence of B's disability, and A cannot show that the treatment is a proportionate means of achieving a legitimate aim. So again, we see this need for unfavourable treatment as a consequence of a protected characteristic. In this case, the protected characteristic is disability, but there is an additional requirement that it cannot be shown that the treatment is a proportionate means of achieving a legitimate aim. So this effectively builds into the test for disability discrimination the justification for indirect discrimination. And that is the first difference between disability discrimination and direct discrimination. that there is potentially a justification for disability discrimination if it can be shown that it was a proportionate means of achieving a legitimate aim. The second difference is that when considering an allegation of disability discrimination, there is no requirement to identify a comparator. So by way of example, a visually impaired person who's not allowed to bring a guide dog into a restaurant passes this threshold simply by showing that this treatment was unfavourable to him or her without having to compare their treatment with that of a non-visually impaired dog owner. And finally, there is a defence that an organisation did not know and could not reasonably be expected to know that B had the disability. So connected to disability discrimination is the duty to make reasonable adjustments. So the duty to make reasonable adjustments is where a disabled person is placed at a substantial disadvantage to a non-disabled person, there is a duty to make changes to, and you'll see in the slides, provisions, criteria, or practices, physical features, and a duty to provide auxiliary aids and services. This is slightly different to the conduct discussed thus far, as it actually requires organisations to do something rather than refrain from doing something. However, what's important to note is that a failure to make reasonable adjustments can amount to discrimination, or will amount to discrimination in itself. So a person can raise an action on the basis that a charity failed to comply with this duty. Effectively, the prohibited conduct here will be the failure to make these adjustments. The way in which the 2010 Act applies this duty is that it says that organisations will be under the duty in certain situations. So, for example, the Act says that the duty will apply in the context of work, education, or where an organisation is delivering a service. Many of us will be familiar with the concept of reasonable adjustments in the context of work. However, I've put some examples on this slide of where the duty to make reasonable adjustments could arise for charities. You see there that an example is a failure by a charity to provide an employee with carpal tunnel syndrome with a modified keyboard, or where a charity provides a service, so for example, a visitor centre, it fails to make the premises wheelchair accessible. Potentially those failures could result in an allegation that the organisation has discriminated against the person for failing to make those adjustments. So this is kind of going back to what Christine had mentioned earlier, where the person concerned is an employee, the Act is quite clear that a charity would be under a duty to make reasonable adjustments. However, where the person is an unpaid volunteer, the position is perhaps less straightforward. There is an argument that, and based on a relatively recent court decision, as we've mentioned, the unpaid volunteers are not employees for the purposes of the 2010 Act, and therefore the parts of the Act that apply to the work and the duties to make reasonable adjustments in that context will not apply to them. However, this does not mean that the duty to make reasonable adjustments will never apply to unpaid volunteers. There could be an argument that because the charity is providing a service or is an association under the Act, that the duty to make reasonable adjustments arise in these situations. So just briefly, the final two types of prohibited conduct I wanted to discuss were harassment and victimization. Firstly, harassment. There are 3 types of harassment under the 2010 Act, and these are where A engages in unwanted conduct related to a relevant protected characteristic, A engages in unwanted conduct of a sexual nature, and A or another person engages in unwanted conduct of a sexual nature or that is related to gender reassignment or sex. And because of B's refusal to participate in that conduct, B is treated less favourably. So the common theme here in all the types of harassment under the Equality Act is the idea of unwanted conduct, which the concept of unwanted conduct itself could capture a wide range of behaviour. However, the Act does offer some assistance in clarifying when unwanted conduct may amount to harassment under the Act. And that is when the conduct has the purpose or effect of either violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment for B. And finally, victimization. Victimization is where one person subjects another to detriment because he or she in good faith does a protected act. So there are two parts to victimization. First is a person must be subject to a detriment, which is slightly different than the less favourable treatment test we've seen elsewhere in the Act. And second, there must be a protected act. And the 2010 Act defines what the protected acts are. Examples of these are bringing proceedings under the Act itself, the 2010 Act itself, or giving evidence or information in connection with proceedings under the 2010 Act. That concludes what I wanted to cover in terms of prohibited conduct. I think Christine will now cover some of the other duties under the Act and some exceptions that apply to charities.
Thanks, Finlay. So if we move on to the next slide, Finlay's been talking mainly about the conduct that is forbidden in terms of the Equality Act. I want to talk about the main positive duty that applies under the Act to public authorities and to those who offer public services. So there is what's called the public sector equality duty under section 149 of the Equality Act. And that's a duty that applies to the organisations that are affected by it to have due regard to certain needs. So the important thing to say about this duty is that you're not under a duty, if you're subject to the public sector equality duty, to achieve particular outcomes. Rather, the duty is one to think about and make reference to in your decision-making processes certain needs. And I don't mean make reference to them in a tick box way, but actually for the organisation to apply its mind properly to the need to eliminate discrimination, harassment, victimisation or other prohibited conduct, to have due regard to the need to advance equality of opportunity in various ways, and to have due regard to the need to foster good relations by tackling prejudice and by promoting understanding, and that's good relations among people with different protected characteristics. So there is a need to have regard to these particular factors when you are engaged in decision making, and that includes decision making about policies and procedures and the way in which you go about your business. So if you go on to the next slide, the 2010 Act specifies the public authorities to which the duty applies, and most charities won't appear on that list because they tend to be conventional public authorities, although there are, for example, universities and further education colleges which are expressly public authorities for the purposes of the 2010 Act and may also be themselves charities. But even if you're not specified as one of the authorities under the Act that's subject to the duty, you may be required to comply with the duty anyway, either because you yourself as a charity exercise public functions. So even if you're not listed, but if you exercise public functions, then you'll be directly subject to the public sector equality duty. And even if you're not yourself exercising public functions, if you are delivering services or exercising public functions on behalf of another public authority, then you may be required, for example, in terms of your contract with that public authority, to comply with the public sector equality duty and the 2010 Act more generally. And we have seen examples of that in local authority commission services, for example, where local authorities will be quite prescriptive about the contractual obligation of the charity to comply with the Act and also to comply with the public sector equality duty specifically. So if we move on, We can come back to the public sector equality duty and questions if anyone wants to talk about that. The other thing I wanted to mention was the range of exceptions that there are under the 2010 Act, some of which will apply to charities. So as Finlay's explained, the Act is structured in such a way that certain conduct is prohibited, and it's prohibited in certain specific circumstances. But the 2010 Act also carves out some exceptions. So the 2010 Act allows for activity that would, under the Act, generally be unlawful, but if it falls within one of the exceptions, it's allowed. Still might not be a good idea, but it would be allowed and wouldn't be unlawful conduct in terms of the 2010 Act. And there is an exception that relates specifically to charities under section 193 of the 2010 Act. And what it provides is it allows for charities to restrict their benefits to groups that are defined by a protected characteristic, provided certain criteria are met. And we'll go on to look at those criteria. So it is permissible for a charity to say that we are only going to provide benefits, our benefit, public benefit, to a group or groups defined by a protected characteristic or protected characteristics, because I think we would accept that reading the Act properly, protected characteristic can include plural. So you might be permitted, for example, to restrict your benefits to women, and you might be able to restrict your benefits to older women or women of a particular age group, provided certain criteria are met, and we will go on to look at what those are. What you may not do, although you might restrict your benefits, for example, to women or to women of a particular age, you may not restrict your benefits by reference to skin colour. That's entirely prohibited by the 2010 Act. So you may not restrict the provision of benefits to a group defined by reference to skin colour. So if we move on to just explain the exception in a little bit more detail, you can rely on that exception in the following circumstances. You restrict the provision of benefit to persons who share a protected characteristic, and you do so in pursuance of your charitable instrument. So your charitable instrument must make this provision for the restriction of benefit. And I just want to make one point about this. The charitable instrument must restrict the provision of benefit to the people who share the protected characteristic. So it's a provision in favour of a certain group. It's not a provision that excludes a certain group. So we're not talking about a charitable instrument that says provision of benefits to everyone except women or except older women. You must be restricting your benefit by reference to a positive identification of a group and a positive reason for doing that. So first of all, it must be in your charitable instrument, and then you have to fulfil one of two different conditions. The first is either that the restriction of the benefit is a proportionate means of achieving a legitimate aim, so back to Finlay's well-worn phrase, or the restriction of the benefit is for the purpose of preventing or compensating for a disadvantage linked to the protected characteristic. And we'll look at each of those in turn. So you must always have it in your charitable instrument, and then you must fulfill one of those two additional criteria. So if we move on first to proportionate means of achieving a legitimate aim, we would be thinking first of all about what is your legitimate aim? Does it have a reasonable social policy objective? So for example, are you restricting your benefits to a group like children for the benefit of children to promote child protection, for example? Is it consistent with the lawful carrying out of your stated purpose for the public benefit? And is it balanced? Is it the least discriminatory way of achieving what it is that you're seeking to achieve? And there's a case called Elias, which is well known by those who work in discrimination law. that sets out various principles that you have to apply when you're thinking about whether something is a proportionate means of achieving a legitimate aim. And for example, one of the principles is that the person doing the discriminating has to justify their discrimination, and it gets looked at with quite a lot of scrutiny. So that's the first sort of limb of the second part of the test. Alternatively, if it's not a proportionate means of achieving a legitimate aim, the question is, will it prevent or compensate for disadvantage? And so in those circumstances, you actually have to be able to show that there is a reasonable connection between what you're doing and past disadvantage experienced by those who share the protected characteristic. The charity would have to demonstrate that there was such disadvantage, and that might be disadvantage around lack of opportunity, exclusion, rejection, barriers to accessing services or education or employment. And then what you're doing in response to that should have a real connection with that particular disadvantage and be capable of making a difference in terms of overcoming it. So if we move on, there are lots of cases on the charity exception. One of the most recent ones is Z against Hackney Borough Council and another. This was a challenge to an orthodox or to a charitable housing association that provided social housing primarily to the Orthodox Jewish community, and the claimant wanted to apply for one of these houses. They were desirable houses, and the claimant was not a member of the Orthodox Jewish community and considered that she had been unlawfully discriminated against. And what the courts looked at was whether there was indeed a real and substantial disadvantage suffered by the Orthodox Jewish community, and the courts decided that there was. And the courts looked at whether the arrangements that the housing association was putting in place allowed that community to overcome those disadvantages. So if we move on to the next slide, this was looked at in the Supreme Court, and the Supreme Court took the view that this was permissible. It was permissible because it was in pursuance of a charitable instrument, and it was for the purpose of preventing or compensating for a disadvantage linked to that protected characteristic. So if we move on, just to conclude on what we want to say, there are other exceptions applicable to charities under the Act, and again they are worthy of being looked at in more detail. For associations, for religious organisations, certain discrimination or restrictions are permitted, and there's also a provision in the 2010 Act around taking positive action to support groups who share a protected characteristic and who've suffered disadvantage. So there are other exceptions, but we could spend again all day looking at those. So if we move on, we'll conclude here, I think, and move to questions, but we just mentioned that there are various things that we can do to help. If you do have issues around equalities law, those are explained on the slide, and we've also given reference to useful resources that you might want to use if you are looking at this issue within your own charity. But Kenneth, I think you're going to manage our questioning.
Yeah, and thanks very much to both of you. That was really informative. One question has come up. There's a few. When we were speaking about charitable instrument, is it good enough to have it in a policy document, or are we speaking about, your deed of trust or your memorandum and articles of association?
The latter, I think, Kenneth. I wouldn't be satisfied with it being contained in a policy document, and I suspect Oscar would take the same view. Not that I can speak for Oscar, but it should be in the charitable instrument. Okay.
Thanks. Another question that's come in is around the use of words when we're speaking about ages. So young, elderly, is there any guidance on what's accepted? Could you easily trip yourself up and end up being discriminatory there if, for example, your charitable purposes are for the young and then you advertise a group for toddlers?
So certainly references to words like young and old can amount to age discrimination, certainly in the work context, even if it's not by reference to a specific age group. So that can be discriminatory on its face. In terms of restricting your benefits to a particular group, I think my advice would be to try and be as specific as you can in your charitable instrument about the group to which you plan to deliver services. I don't think that the old or young is entirely kind of out of the field, but I think the more specific that you can be, the better. And once you have been specific, then it's quite important that you act in accordance with your charitable instrument. So as you say, if you're delivering services or planning to restrict the benefits to the over, I don't know, the over 65s, and in practice you actually only deliver services to over 75s and you exclude that other age group, then that may be problematic.
Yeah, thanks. One in from a grant giving charity, is there anything specific that grant giving charities should be thinking about? So maybe putting conditions in grant award letters, asking the recipients to comply with equalities law, would that be something they should maybe think of?
Finlay, I don't know if you want to respond.
Yeah, I think, I mean, in terms of the compliance of the equalities law, I suppose that's one part of it that we touched on earlier, where you can effectively ask that. But in the concept of grant giving and restricting a benefit, I suppose there's the risk there of discrimination potentially. What's always going to be important is, if there's the potential for discrimination to arise, is having a think about whether or not any of the justifications that we spoke about or any of the exceptions apply. So obviously, if it's in relation to indirect discrimination, if that's thought that might happen, then charity could think about if there is a proportionate means of achieving a legitimate aim. It might not necessarily matter as much exactly what its constitution says. However, if there's direct discrimination, as Christine touched upon, in relation to the charities exception, you're going to need to be thinking about if it's in pursuance of the charitable instrument, and well, either if it's a proportionate means of achieving a legitimate aim, or if it compensates for some disadvantage.
Yeah, thanks. And as we move, or as we hopefully come out of lockdown for the last time, and everybody's thinking about blended approaches to meetings, to AGMs, and to conferences, on an accessibility point, will we now have to think about digital access, and we might failure to do so present challenges?
Yeah, I think, I mean, I think that we've all been surprised actually by what the pandemic has shown us is possible in terms of digital access. And I think that you're liable to see, I don't mean more claims, because I don't mean it in a litigious way, but I think people, particularly with disabilities, are liable now to think more carefully about whether the reasonable adjustments that might be made for them, and you as an organisation should be thinking about this, whether a reasonable adjustment is holding a meeting virtually rather than physically, if that is the most accessible way for people to attend.
Okay, thank you. Well, I'm afraid that's all we have time for today. I hope you found the session useful. We'll be running further webinars later in the year, and to make sure you receive information, please sign up to our mailing list, and we'll include a link when we circulate this webinar. Also, please feel to get in touch with us if there's anything you'd like advice on, whether in relation to equalities law or any other legal or governance matter relating to your charity. Our details are there, and we would be, and personally I'd be delighted if you got in touch with me, and I can certainly connect you with the right colleague in our team. So thank you very much for your attendance today, and enjoy the rest of your day.